Tim Mahoney is back tonight. We love when you stop by and fill us in on something that maybe we've all been wondering, which is what we're going to talk about tonight.
Right. So what we're going to talk about tonight is lawyers' compensation, how you pay your attorney. Because, you know, I'm in my 33rd year of doing this, and it's amazing how people still don't quite understand how lawyer compensation works. And that's because it varies depending upon what it is that you're doing. So let's say what I do. I'm a personal injury, almost exclusively personal injury litigation. That's a type of case where a lawyer can take it on a contingency fee. So you've heard the we don't get paid unless you get paid type thing. Well, what that means is unless we are successful in the litigation, we don't get paid. And if we are successful, we get a percentage of the litigation. Now, lawyers can only do that in a certain type of case. If it's got to be a case where the lawyer's interest and the client's interest are aligned, and this is decided by state law. They tell us what we can and can't do in terms of that type of relationship. So personal injury cases, you can do it. That includes like medical malpractice cases. That includes products liability cases. Workers' compensation cases can also be like that. And also class action lawsuits can operate like that. There are regulations regarding it. There's got to be a contract. So if you call up an attorney on a personal injury case or a workers' comp case and they say, well, I need you to sign a contract, that's because technically they don't represent you until you sign the contract. The contract will cover all of the aspects of the relationship. Now, other cases, you can't do that. So like a divorce case, you can't do on a contingency fee. So divorce cases, criminal cases, those types of cases are what we call an hourly rate. Every lawyer has an hourly rate, even I do, even though I rarely charge an hourly rate. In that type of situation, lawyers typically operate on what's called a retainer, which simply means that you pay a certain amount of money up front, which is a credit.
Okay.
So like, let's say you hire somebody for a divorce and they say, I require a $5,000 retainer. So that means it's not $5,000 and then you're paying them on top of that. It's $5,000 and that's a credit that they're working against.
Okay.
They have to put that money in what's called their client trust account. Every lawyer has a client trust account, and any money that is our clients goes into that trust account. And you can do a lot of stuff as a lawyer and not lose your license to practice law. You can commit felonies, you can do all kinds of stuff. But if you touch your client's money, you'll lose your license to practice law, or at least you'll get in really big trouble. So that is one huge no-no. So once the money goes in to the client trust account, in order for it to come out, it's supposed to be that you have a written engagement agreement, you've got a contract, and they have to present you with a bill. Say, this is what I'm charging, and they can do it monthly, they can do it quarterly, they can do it whenever they feel like it. But this are my charges. If you have any objections to those, then we're supposed to talk about it. And then once it's authorized, then the money goes from the client trust account into the lawyer's account. So when you do a retainer, then you have a credit. Now, there are certain limited situations where you'll hear somebody say, well, I have so-and-so on retainer.
Yes, famous people.
Right. That's kind of a big city kind of thing. That typically means it's a lawyer that's well known and has and so what you do is you say, look, I want you to be my lawyer no matter what. So I will agree to pay you monthly a certain amount of money so that you're my lawyer. And then when I need you, I will pay you hourly on top of that.
Okay.
Okay, so that's a very limited situation. I don't know if that even...
No one
I've never had that opportunity. I don't know if anybody does in the Rockford area, but that's not something that you see a lot around here. There are other cases that you can do on a contingency fee. Some contested estates you can do on a contingency fee. And then the other thing is criminal cases. Criminal cases many times are done on a flat fee. Not always, but they can be, where it's like, for this case, I'll charge you this much and then that's it, okay? That a flat fee has to be clearly defined that this is a flat fee, and that doesn't go into the client trust account. That just goes once we sign the agreement, and the deal is, I'm gonna stay in this case and finish this case until the case is done for X amount of dollars. One of the reasons that a lawyer would do that, they want to get all the money up front, is because a lot of times in a criminal case, if things start going awry, a judge will not necessarily let you leave the case. In a civil case, you can get out of the case virtually without limitation. That's not 100%, nothing in law is ever 100% true. But in a criminal case, there are many times where you say, look, Judge, my client and I aren't communicating, or this case didn't go, and the judge will go, that's tough, you're in the case and you're going to stay in the case. So a lot of times that's why flat fees are something that you see in criminal cases.
Well,
so there you go.
This is a lot of information that I think I took in, but if I have any questions, I'm going to call Tim, and you can too. You can check him out online, you give him a call, or on Facebook. Carrie's popping in next from the Rockford Area Habitat for Humanity Restore, and then we're learning how to make balloon arches on Tuesday Tips. We'll be right back.